Welcome to the session on the Payment of Bonus Act 1965. I will just take you through a little background of the case. Actually, the Payment of Bonus Act appears to have originated during the period of First World War, when the textile mills started giving 10% towards the bonus to the workers. And also, under Defense of India rules, Rule 81A, then they also started giving some type of a bonus. Then the Industrial Disputes Act also started referring some cases of payment of bonus. Then in 1950, a full bench labor appellate tribunal evaluated a formula for determination of bonus. A plea was made to in the 18th session of Labour Committee held in New Delhi, that it was agreed that a commission be appointed going to question a bonus and evolve a suitable norms. On 6 December 1960, the government appointed the Bonus Commission. The Government of India on September 2nd accepted a recommendation and the subject to certain modifications. To implement these recommendations, the Bonus Act 1965, first of all, the ordinance was passed and subsequently it was Act was promulgated and in September 25th, 1965. Now the Bonus Act 1965 has come into operation. This is an act to provide payment of bonus employed in certain establishments on the basis of profits or on the basis of production and productivity and matters connected therewith. Actually, when the Bonus Act was amended in 1965, the payment of bonus was linked to the profitability, in the sense that if the organization is making profit, then it can pay bonus, and depending on the level of profit. If the company has incurred loss, no bonus will be paid. That was the concept under which the Bonus Act 1965 started. Ever since, various amendments have taken place since 1965, and the bonus linked to profitability has been totally eroded, in the sense that it has come to almost a statutory payment irrespective of the anything. In other words, even if the company is under loss, they need to pay a minimum bonus of 8.50%. That's why it has come. Now, on account of all these things, it has become an assured 1 month salary. It means that it has become the fashion of a deferred wage. In other words, if a person works for 12 months in a year, he is going to get 13 months salary, in other words. More or less it comes to that. As the Applicability Act is concerned, it is applicable to all the establishments employing 20 or more persons. It has been extended to all, that includes all Shops and Establishments Act. It comes to say wherever 28 or more persons are employed, the Act is automatically becomes applicable. However, the Act is not applicable in certain cases where it has been exclusively mentioned in the provisions of the Act, namely the Red Cross Society of India or any other institutions like nature. And universities and education institutions are out of the purview of the Payment of Bonus Act. Institutions, including hospitals, chambers of commerce and social welfare institutions, established not for the purpose of profit. That's very important. If they are established not for the purpose of profit, they are excluded. Then employees employed through contractors on building operations, they are not covered. And all central and state government offices and undertakings, local bodies and various corporations, etc., they are excluded from the purview of the Act. In fact, if you see publicity undertakings like large publicity, including railways or P&T, they are not covered under this Payment of Bonus Act at all. They are not covered. Employee here, the definition of employee is that a person who is drawing, in other words, to tell you shortly, a person who is drawing a basic and day annual salary of, as per the latest amendment, 21,000 rupees. Limit has enhanced from 2016, it has come to 21,000 rupees. Any person is getting a less 21,000 rupees or less the basic and dearness allowance is an employee under the Act. Here also there is no categorization. In other words, any category of employees who falls into this salary limit, he is eligible for payment of bonus, for payment of bonus. This is the definition of the employee under this Act. Wage or salary means all emoluments, and it excludes all the allowances and other things, in what includes the dearness allowance. That's why, in other words, it means the basic plus dearness allowance. But if they compensate special pay or CCA, then it will be inclusive. That's very important. If they compensate special pay, almost it is considered the additional basic cost for, then CCA is nothing but another form of dearness allowance to take care of the cost of living in a particular city. Hence, they are also to be included. Otherwise, it's only a question of basic and dearness allowance. Now, in the Payment of Bonus Act, you will find the definition of allocable surplus. Allocable surplus is if the company is a foreign holding company. If the company is a foreign holding company, then it is 67% of the available surplus has to be taken into account. In any other case, it is 60% of such available surplus. We will just explain the calculation of available surplus, how it is done. We will just go through that. Then available surplus is also defined. Available surplus is in respect of an accounting year shall be the gross profits of the year after deducting therefrom the sums referred to in Section 6. In Section 6 of the Act, broadly, the following deductions are to be made. That is depreciation under Section 6A of the Act, development rebate or development allowance under Section 6B of the Act, direct taxes under Section 6C of the tax, and further sums as specified under the third schedule of the Act. So if this is complete, then it becomes the available surplus. We'll just go through when we deal with how to calculate the available surplus. Gross profits means the gross profits calculated under subsection under Section 4 of the Act. The Section 4 stipulates the calculation of gross profit. In the case of banking company, the calculation shall be done in the manner specified in the first schedule. In any other case, the manner specified in second schedule of the Act. See, the Act contains two schedules, Schedule 1 as a first schedule and second schedule. This schedule is a very, very detailed, comprehensive schedule which you can refer in the Act itself. It runs to several columns and the calculation has to be done based on as per the schedule, then only it will come. So please refer the schedules of Schedule 1 and Schedule for this. Now here, Section 3 says the establishment to include departments undertaking of branches. See, all departments, branches, undertakings, whether situated in the same premises or located in different premises, shall be treated as the same establishment for the purpose of computation of the Payment of Bonus Act. It is taken as one. But however, there is an exception. If, however, such branches or undertakings are maintaining separate balance sheet and profit and loss account, then they will be treated as separate establishment and the payment of bonus shall be governed as per their profit and loss account and balance sheet. This is very important. And if this is a practice, if they followed in the past a commonality, then they cannot deviate from that. So we have to follow that. So that's very important. Unless a department again were immediately before the commencement of that financial year treated as part of the establishment for the purpose of competition. In other words, if we already decided that this shall be the mode of consideration of the balance sheet for this, then the same thing has to be followed. In other words, in the previous account, starting with the financial year, if you have decided that there should be a common balance sheet, then you cannot change it, you have to observe the same thing. In the previous year, if you have decided, for instance, you shall just maintain separate profit and loss account for separate undertaking, then this should be followed, and afterwards you cannot change it. So it is only a one-time activity, you need to change it. It means that if you have one system, you cannot switch out to other system, because depending on inconvenience, you can do it, it has to be on the same. So ever since the Act came into force, number of amendments have taken place. Major amendments have taken place in the years 1974, 1976, 1977, 1978, 95, 2000 and now it is 2016. Major amendments had taken place in the years 74, 76, 77, 78, 95, 2007, now it is 2016. From minimum bonus of 4% to 8.33, from profit or loss concept to compulsory payment of minimum bonus. Eligibility criteria has gone up from 3,500 to 10,000, now it is 21,000. Calculation ceiling has gone up from 2,500 to 3,500, now it is 7,000, or the applicable minimum wages whichever is higher, that is 2016 amendment. This is another thing. Then the induction of section 31A, that is called productivity linked scheme. I will just come to this later. These are the major amendments that have taken place. So as a consequence, all employees whose salary is 21,000 they are eligible. There is no distinction between the categories of employees, all are eligible. They must have worked at least for 30 working days in the establishment in the relevant accounting year, then they will be eligible for payment of bonus. How much bonus is payable? Section 10 says minimum 8.33. Then section 11 says maximum 20%. Then section 12 says when the wages of an exceeds 7,000 per month, the bonus shall be payable as calculated on 7,000 rupees or applicable minimum wages of scheduled industry, whichever is higher as of 2016 amendment. Suppose the minimum wages in the scheduled industry is 10,000 rupees, the bonus has to be calculated on 10,000 rupees. If the minimum wages in scheduled industry is 8,500 rupees, it has to be 8,500 rupees. So that is the effect of this 2016 amendment. Now when the bonus is payable, the bonus is payable within 8 months of the closing of the financial year. It means that if the financial ends on March, the bonus has to be paid before 30th November every year, or within a month from the date of award, enforceable or settlement comes into operation in case of any dispute is there. Then there is a provision for disqualification of bonus also. Here, if an employee is dismissed, this is very, very important. If he is dismissed from the services for fraud, riotous or violent behavior while on premises establishment, or theft, misappropriation, sabotage any property of the establishment, if he is dismissed on account of that, he is disqualified from the payment of bonus act. But you need to follow the procedure of issuing a show cause notice to him. Why the management should not disqualify you from payment of bonus on account of the fact that you have been dismissed for this misconduct, you have to seek an explanation and then only pass orders. So without issuing a show cause notice and hearing from him, the withholding bonus cannot be done. Then under section 23 of the Act, there is presumption of accuracy. In the sense, the profit and loss account and balance sheet of the company, if it is audited and then certified and adopted in the general body, it is presumed to be correct. Nobody can question that. Presumed to be correct. Only in case if the tribunal or the labor court, if they insist or they seek some clarifications or they want some doubt, then to that extent you can always furnish the same and furnish accordingly. Now the next question is computation of calculation of bonus, how it is done. Step number 1, first of all we need to calculate the gross profit. As I told you already, the calculation of gross profit shall be made as per Schedule 1 or Schedule 2 as the case may be. Now both schedules prescribe the method of calculation of gross profit. Here the gross profit what you arrive here and gross profit what you see in your balance sheet will not be same, something different, lot of difference will be there. Here to start with, you have to take the net profit from the profit and loss account is taken and work back as per the schedules to arrive at the gross profit. The gross profit shown in the balance sheet will be different from this gross profit so arrived, that's what I told you. Then once you arrive at that, step number 2, that's called available surplus. This available surplus in respect of accounting year is the gross profit as determined in step 2, that is the first or second schedule, minus the deduction under section 6. In the definition clause, I explained to you what are the deductions under this. So when you arrive at the gross profit as per the schedule, you have to deduct the items in the section 6. Section 6 or main deductions are depreciation admissible as per Income Tax Act, then development rebate or investment allowances, direct tax, and further sums as specified under the third schedule to the Act, thus the available surplus will be calculated. So friends, you had to literally see the schedule and keep the balance sheet and the schedule and work on this, because I am trying to give you a broad framework of the calculation how it is done. When allocable surplus is taken, then allocable surplus 67% in case of a company is a foreign dependent company, and other than a parent company, in all cases it is 60%. So the amount so arrived as allocable surplus, the 67% or 60% as the case may be, then that will be the bonus available for disbursement. This is how it is calculated. Then that money has to be distributed to the people who are eligible based on their basic container allowance, and you can arrive at the percentage accordingly. This is how the system is worked out. Now there is another important thing to be taken into account while the bonus is decided accordingly. This is called set on and set off of allocable surplus. In an accounting year, the allocable surplus exceeds the bonus payable, then the excess amount shall be carried forward to the next year as set on. I will explain to you in the subsequent slide. I have prepared a table. I will just explain to you how that mechanism works. Then in any accounting year, if there is no allocable surplus, or the allocable surplus falls short of paying even the minimum bonus, then that shortfall so paid shall be carried forward to the next year as set up. In other words, supposing you have got excess profit in a particular year, and then you are supposed to declare maximum 20% bonus. After declaring 20% bonus, if any money is left over, that leftover money should be carried to the next year. You have to carry forward, it cannot lapse, it has to be carried forward. Similarly, if you are forced to pay minimum bonus, although you have incurred loss and there is no money available or less money is available, but still you have to pay minimum bonus. So it means that you are paying from your extra pocket. That money you can carry forward for adjustment to the next year. This is called setup. So here, the set on and set off principle is extremely important in the case of calculation of bonus. Now, look at this slide, then you will be able to understand very clearly. Here I have mentioned the first year. Available surplus as bonus. That is, let us say, this is a simple illustration figure what has been taken. Let us say it is 1,04,167. Now, the 1,04,000, let us say it exactly matches with minimum bonus. Because statutorily you have to pay 8.3 bonus. So if you pay 8.3% bonus, let us say the amount comes to the same thing. That is 1,04,167. So you pay that money. Then what happens? You have got allowable surplus of 1 lakh and you are paying 1 lakh, then there is no question of set on or set off, both are made. So what you have got surplus, you are distributing the minimum rate, there is nothing. Next year, you make huge profit. The available surplus comes to, let us say, 6,35,000 rupees. So 6,35,000 means, even if you pay at the rate of 20%, the money will be 2,50,000 rupees. So it means that you have got more money in the pocket, that is 6.35 you have got, but you are supposed to pay only 2.5 lakhs. It means the balance of 2.5 lakhs is carried out. Now you can ask a question as to why only 2.25, the difference is much more than that. But the law provides that the set-on shall not exceed the maximum bonus payable. It means that you can't carry forward any money. You have to carry forward only to the extent of 20%. That's why here 2,50,000 is carried on for next year. That's how it is carried on. Now let's go to third year. Third year your profitably comes down. It means that only 2,20,000 is available. But you have got a surplus money of 2.5 lakhs of the previous year. You have to draw that money. If you draw that money, you are able to pay again 20% at the rate of 2.5 lakhs, even though you have got less money in allocable surplus because the previous year's amount you are taking. So then what happens? The total set on after the balance is 2.2 lakhs you are carrying for the next year. Then fourth year, let us say you make only available surplus of 3.75 lakhs. Then here again you have got money to pay 20%, although your profitability is little less. That is again, if you pay 2.25%, your carry forward, your set on is reduced to 1.25 lakh, 1.25 your carry forward, and set on is 2.2 lakhs of the previous year, and current year 1.25 lakhs you are carrying forward. Then fourth year, let's say you don't make any profit at all, it comes down to 1.4 lakhs. But your set on you have almost 3.45 lakhs as set on. It means that you have got 2.25 lakhs to be paid at 20% bonus. Still you can carry forward 1,10,000 and 1,25,000 the fourth year. See, like this, you have to just go on like this. But only thing is, the set on and set off shall be carried for the period of 4 years, and fifth accounting year it lapses. It not only carried a perpetual, it has got a life for only 4 years, fourth accounting year it lapses. That's how it is that. So this is how the bonus calculation is done. This is extremely important in calculating the payment of bonus, and then only it can be done. Then there are special provisions regarding certain establishment. Let us say, for instance, a new establishment set up, a new factory is set up. There is a provision has been made for first 5 years, you need not pay the bonus because that is called infancy period. No bonus is payable if the establishment do not make any profit. A safeguard has been given to the new companies. However, if the establishment makes profit during any accounting year within 5 years, then the bonus shall be calculated under the Act accordingly and you have to pay. Then here there is no question of set on and set off. You have to just calculate if you got money surplus, you pay this to the stock. In the subsequent year or years, within 5 years, if you don't make any profit, then the bonus is not payable at all. No question of paying bonus. Then from 6th accounting year onwards, the set on set off starts. Then as the case shall be made, of the allocable surplus set on and set off in the 5th and 6th accounting years. 7th accounting years, set on and set off shall be made, taken into account the set on set off the 5th, 6th and 7th accounting years. Thereafter, from 8th accounting year, it will be just like any other establishment. So this is how the mechanism has worked out in case of new establishment. So repeat, for first 5 years you need not pay the bonus, provided you don't make any profit. Suppose in any financial accounting you make a profit, the bonus has to be calculated for that accounting you have to pay. In subsequent years, if you don't make any profit, you need not pay. But from 6th accounting year, set on and set off as the case may be made, and allocable set on set off in respect of 5th and 6th year also, and start paying. From 7th year, set on set off shall be made, taken into account set on set off for the 5th, 6th, 7th accounting years, and thereafter it follows. That's the right. In case the existing establishment consists of different departments or undertaking branches and has been paying bonus based on the consolidated balance sheet and payment of bonus act, the employer will have to pay the bonus based on such consolidated account, and even to the new department or undertaking, then this benefit is not available. This is very important to note. Even though an employer starts a new company, in addition to his companies, other establishments, and if he is operated on a common balance sheet and common profit loss account, then even though he starts a new company, you have to follow the same principle of combined balance sheet. Even though it's a new company, even the first year also, you have to pay the bonus. So this is the provision of law as far as the payment is concerned. Now, as I said already, Section 17 permits an employee to deduct customary bonus, puja bonus, or in advance pay in the financial or the final account payable. This can be deducted because many times some people will pay advance bonus which can be adjusted, or puja which can be adjusted, but it has to be documented properly. That's very important. So once it's documented properly as paid as bonus, you can adjust in the final pay into the bonus. Now here the employer can deduct the bonus of any employee found guilty of misconduct causing financial loss to the company. Such amount he can deduct. However, here important thing is that an inquiry to be conducted and he should be found guilty of the charges and punishment ordered. Then one more show cause has to be issued to him as to why this clause should not be invoked to stop the payment of bonus. Then only you can do it, otherwise it becomes an illegal issue. Then one more concept is there that is called section 31A, payment of bonus linked to production or productivity. Here, both employer and the unions, if they come to any kind of productivity linked settlement, then based on the productivity, you can always link the percentage of bonus what is to be payable. Then the question of the payment of bonus based on the profit or loss doesn't arise. It's purely on the basis of productivity. Various productivity standards can be worked out and at different levels you can fix up. But however, one should make sure that they get the minimum bonus of amount equivalent to minimum of 8.3%, they must get it. Maximum of 20% they should be able to get it. Within these parameters, the incentive amount has to be fixed upon. If there is, actually for this, there should be a formal settlement in the union and worker, then only this can be done. So this is quite possible. And some companies have done it, particularly cement industries, they have experimented this and they get the benefit out of this. But somehow this concept is not much popular. People tend to depend only on the profit and loss of the company, depending on that they do that. Then there are some few cases like city compensatory allowance will form part of wages. I told you already. City compensatory is nothing but another form of dearness allowance. The important thing is the bonus is not payable on suspension allowance since the employee has not actually worked. This is very important because we place many instances are there. The workers are placed on suspension pending inquiry and we pay subsistence allowance. See, on that the bonus is not payable. Bonus for all the years will not be payable if you indulge in riotous and violent behavior as per Madras High Court decision. A daily wage employee also will be eligible under bonus provided he has worked for 30 days in the accounting year. This is very important. Then here another important statement is that the principal employer is not liable to pay the bonus of contract employees. The Karnataka High Court has held in the case of Hindustan Liver in 2013 and launching prosecution against the principal employer for non-payment of bonus to contract workers is to be quashed. Because the simple argument here is that if you see the definition of employee in the Payment of Bonus Act, it does include the employees engaged through contractors or by contractors, not there. Hence, the question of payment of bonus to contract employees do not arise at all. So, this is all about Payment of Bonus Act. Thank you.